it is unconstitutional for an executive to attempt to arrogate from the legislature its prerogative to determine and pass laws of its choosing. So that's the first concern, constitutional concern we raise with respect to Bill 32. The second is that not only does the executive, through this instrument in the bill, attempt to assume powers that properly belong to the legislature, the sitting legislature, but it purports to do the same thing with respect to future legislatures. By imposing on those legislatures, the government, future government, constraints arising under TILMA, and most notably the one that it can be punished. Those future governments can be punished for doing things that are, while entirely lawful and constitutional, nevertheless offend TILMA rules, as those arbitral tribunals may at some time in the future decide the rules to be. In fact, we're told by Minister Hanson that the whole purpose of the bill is to constrain the exercise of legislative authority. That, again, is something that the courts in Canada have taken a very dim view of for the same reasons that they have resisted efforts by executives to empower themselves to pass regulations overriding the will of provincial parliaments or legislatures. The third constitutional problem we've identified with TILMA has to do with the attempt of the agreement and the bill to arrogate power from the courts by delegating the judicial authority that under our Constitution is invested in Canadian courts to resolve disputes between individuals and companies and the states concerning public policy and law. If you have a problem in this country, you're a company trying to sell a particular product, perhaps a hazardous product, and the government is doing something to prevent you from doing that, there are two places you can take your complaint. If it's a political problem, you can go to the politicians. If it's a legal problem, you can go to court. You can't take a complaint about something that governments have lawfully done to an independent arbitral tribunal operating largely outside of the parameters of Canadian law and constitutional law. Yet that's precisely what TILMA authorizes. So instead of going to a BC court because you have a complaint about an environmental regulation in the province, now you can take your complaint to an arbitral tribunal and end up with a monetary award if you're lucky, because the government refuses to accede to your complaint, even though a tribunal has found the government to be out of line with its obligations under TILMA. The constitutional authority of Canadian courts is protected by Section 96 of the Constitution, and in our view, TILMA offends, and the bill that would implement TILMA offends that constitutional safeguard. The last one has to do with, you might describe this as an attempt by the province to assume federal authority, because under our Constitution, trade and commerce is a federal head of constitutional jurisdiction that doesn't belong to the province. And the courts have struck down, not infrequently, provincial measures that ignore those constitutional limits, which raises an important question about what TILMA is in the first place, because if it's really about trade, investment, and labor mobility, anything the province did that actually interfered with trade, investment, and labor mobility would offend trade and commerce powers and could be challenged on that ground. In our view, most of the measures that would be constrained by TILMA have nothing at all to do with interprovincial trade or investment or labor mobility. Even if they indirectly have some impact on those matters, they are by pith and substance matters within provincial jurisdiction. Nevertheless, under TILMA, a tribunal may award or authorize retaliatory trade sanction. The purpose of that sanction would be to interfere with interprovincial trade and commerce, and for that reason would offend the limits of provincial constitutional authority with respect to such matters. So those are the four respects in which, in our view, this regime and Bill 32, which would implement it, offend the very bedrock principles of the rule of law, of democratic authority invested in provincial legislatures, that upon which Canadian constitutional arrangements are founded. So perhaps I've given you too much information, but there's my summary.
Any questions for Shrybman or O'Neill?
I have two. First of all, to either of you, to your knowledge, is there any precedent of a province initiating legislation similar to this TILMA legislation?
No, the regime is entirely, I mean, the only precedent for the TILMA agreement itself is the Agreement on Internal Trade. But the Agreement on Internal Trade didn't include legally binding enforcement mechanisms, and there's no provincial legislation implementing it that we're aware of. So the notion of two provinces negotiating an agreement that creates a legally binding mechanism to constrain the activities of its own government to do things that are lawful and constitutional is entirely unprecedented.
My second question, and I'm sure you're probably curious about this yourselves, if the TILMA legislation stands and independent arbitrations are set up, who would monitor the conflict of interest of the arbiters in situations like that, if they were to arise?
Well, I think the agreement does stipulate that people nominated by the province are to be free of conflict of interest, but I don't think there's any accountability mechanism there. And perhaps more problematic is the fact that there are really no qualifications that are set out for who would be appointed to these tribunals. Even if you thought empowering an ad hoc arbitral tribunal to pass judgment on the lawful actions of a school board in British Columbia made any sense, we don't. So the problems we have with the mechanism go well beyond the fact that it's relatively untransparent and unaccountable, and the people that sit on these tribunals may have conflicts of interest for that matter, or just simply be unqualified to do the adjudicative work that's been assigned to them. But the nature of the task is corrupting and unconstitutional in our view.
Hypothetically, could you or your firm correct this legislation, the defaults, so that it would achieve some public purpose, or is the whole thing need to be burned?
Yeah, I don't think there's anything that's salvageable in the legislation. I think what might be salvageable is the notion of trying to deal with real impediments to labor mobility. I don't really think there are. I mean, we've certainly done our best to try to determine whether or not there are actually any trade impediments or investment impediments that exist in British Columbia and Alberta. We can't find those. But there are rules and regulations that apply to the licensing of doctors and lawyers and nurses and carpenters and machinists and machine operators. And they can vary from province to province, sometimes for good reason. There are differences that perhaps aren't warranted. And there's been a lot of activity, I think, over the last 10 or 15 years to try to resolve duplicitous licensing requirements. There are various programs in place. I think progress has been made, significant progress has been made on that front. Perhaps more progress could be made, but you wouldn't need an agreement like this to get there. Those are political problems, and it's perfectly appropriate for ministers and premiers to sit down one with the other and try to sort them out. But this whole notion that there are significant trade barriers as between Canadian provinces, I think, is one that would have most Canadians properly scratching their heads to understand.
It's difficult to actually know the purpose of the legislation in the first place, as Stephen has said. That in simple terms, if you asked a worker who was working in Fort McMurray how much mobility problems he had with labor when he started to work there, or vice versa in Vancouver, or whether or not unloading one hay truck between Alberta and BC constitute putting a trade agreement together, I'm not sure whether or not the purpose of this legislation is very clear, and certainly the questions that we asked, more likely, I would think, in my view, that it's a push to kind of lower the common denominator around qualifications, around workers' rights, benefits, workers' compensation, and those kinds of things. If I was to guess, that's what it's more relevant, and that's what it's all about in my view.